Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome to the Deep Dive, where we cut through the noise and get straight to the fascinating nuggets of knowledge. You've brought us a stack of sources on a really interesting patent appeal. And this deep dive, it's all about what truly makes an invention new, deserving of protection.
Exactly. We're looking at a high-stakes legal battle.
Involving a big automotive player, right?
Yeah.
And it really gets into the weeds of what inventiveness even means.
It does. It's centered on a Madras High Court judgment.
So whether you're in business, maybe interested in law, or honestly just curious about how big companies protect their ideas, this case, it offers some incredible insights. It's about that delicate balance, isn't it? Protecting new ideas versus fostering competition.
Precisely. And what's really fascinating, I think, isn't just the gadget itself.
Right.
It's how the High Court really picked apart the whole patent examination process.
Oh, okay.
It's a critical look at what constitutes an inventive step, that non-obvious leap beyond what's already known.
That sounds pretty fundamental.
It is, and why the Patent Office needs to be, incredibly precise in its decisions.
So what does this all mean for you listening? Well, it's about understanding the bedrock principles that let innovation thrive and how the courts try to ensure fairness.
Let's unpack this. Okay, to begin, let's set the scene. Who are the main players here? Which court are we talking about? And what's the timeline?
Right, so the case is officially CMA number 2115 of 2021.
Okay.
It was heard in the High Court of Judicature at Madras. The judge presiding was the Honorable Mr. Justice Senthilkumar Ramamurthy.
And the judgment date?
Quite recent, actually, July 8, 2025.
Got it. And the parties involved? Who's appealing?
The appellant, that's the company wanting the patent, is TVS Motor Company Limited. They're based in Chennai.
Represented by Mr. S. Harish for Ms. Thriyambak J. Cannon.
That's right. And on the other side, the respondent, the body that initially said no to the patent.
That would be the Patent Office.
Exactly. The Deputy Controller of Patents and Designs from the Patent Office in Chennai, represented by Mr. J. Madanagopal Rao, SPC. Okay, so we have TVS versus the Patent Office. What's the backstory here? How did they end up in the High Court?
Well, the journey started way back 2012.
2012, wow.
Yeah, that's when TVS filed their Indian patent application, number 784CHE 2012, for this Accelerator Safety Control Device.
Okay.
Then, fast forward quite a bit to July 6th, 2018, that's when the Patent Office issued the first examination report, the FER.
And that's where the problem started.
Pretty much. The main objection was lack of inventive step. They cited some existing stuff, prior art documents, D1, D2, and D3.
Right, prior art, things already out there.
Exactly. So TVS replied to that FER in December 2018. There was a hearing in September 2020. They submitted arguments in October.
A lot of back and forth.
Definitely. But the key moment, the initial rejection, what's called the impugned order.
The decision being challenged.
Yes. That came on January 18, 2021, and that's what pushed TVS to file this appeal, CMA number 2115 of 2021, in the Madras High Court.
Which led to this judgment we're discussing now.
Precisely. The July 2025 judgment.
Okay, so quite a journey. But what is this Accelerator Safety Control Device? What does it actually do?
So the invention itself is designed specifically for two-wheelers and three-wheelers. Think scooters, motorcycles, torque shaws.
Okay, not cars.
Right. And it's meant to be on the handlebar. Its main purpose is pretty straightforward, really, and quite important for safety.
Which is?
To disengage the accelerator when the brake is being used.
Ah, so if you hit the brakes, you can't accidentally twist the throttle and speed up.
Exactly. It prevents that simultaneous braking and acceleration.
Makes perfect sense from a safety angle.
Yeah.
So what did TVS claim was unique about their design, especially for these two- and three-wheelers?
Well, Claim 1, the main independent claim, described a whole setup. Handlebar, the grip, a sliding carrier, guides, the throttle cable, a stopper, a brake link, brake lever.
A lot of components working together?
Yes, all integrated onto the handlebar. The novelty, TVS argued, was in how these specific parts worked together in the specific context of a two- or three-wheeler's handlebar system. They said it was distinct from other vehicle types.
Okay, so the context, the handlebar on a two- or three-wheeler, was key to their argument.
Very much so.
Now let's get into the core disagreement. This is where it gets interesting, right? TVS clearly thought they had something new. What were their main arguments against the Patent Office's rejection?
They raised several points in the High Court. First, they suggested the controller might have looked at the wrong version of their claims. An earlier set, maybe, not their final 7 claims.
Procedural issue there.
Potentially. But crucially, they hammered home the point about the vehicle type. Two- or three-wheelers, handlebar operated.
Right.
They argued the prior art the Patent Office used D1, D2, D3 was just irrelevant.
Why irrelevant?
Because, according to TVS, all of those were for four-wheelers, cars, and involved pedal-operated systems, not handlebar grips.
Pedals versus handlebars.
Exactly. TVS argued you couldn't just equate solving a problem in a car's pedal system with solving it on a motorcycle's handlebar. Different mechanisms, different ergonomics.
Okay, that sounds like a pretty strong point. What else?
They also claimed their detailed written arguments, where they apparently had a table comparing their invention to the prior art, were completely disregarded by the controller, and they felt the controller just wrongly concluded that all the bits and pieces of their invention were already present in that prior art.
So TVS is basically saying, you got our claims wrong, you compared us to the wrong vehicles, and you ignored our explanation.
That sums it up pretty well. Strong points, as you say.
So how did the Patent Office respond? How did they defend, saying no inventive step?
Well, the Patent Office stuck to its guns on the lack of inventive step argument. Their main point was that the fundamental problem being solved...
disengaging the accelerator when braking.
Right. That core problem was identical to the one addressed in those prior art documents, D1, D2, and D3.
Even if the vehicles were different.
Yes. Their counter-argument about the vehicle type difference was basically that adapting it from a four-wheeler pedal system to a two-wheeler handlebar system was just a workshop improvement.
Workshop improvement. That sounds a bit dismissive. What does that mean legally?
It implies it's just an obvious modification, something any reasonably skilled mechanic or engineer in that field could figure out easily without any real inventive spark.
So not deserving of a patent monopoly, because it's just common sense engineering for a different context.
That was their stance. They argued it wasn't a real invention, just putting existing ideas together in an obvious way for a bike instead of a car.
Did they back this up with legal precedent?
They did. They cited a couple of cases. This one, Prasad Radhe Shyam v. Hindustan Metal Industries from 1979, arguing against patents that just block a craftsman's normal skills.
Okay.
And a more recent one, Limus Novel Technology GmbH v. Assistant Controller of Patents and Designs from 2025, which apparently discussed different ways to analyze obviousness.
So they were arguing TVS's solution, while maybe useful, wasn't truly inventive in the legal sense.
Exactly. Obvious, not inventive. That was the core of the rejection.
Okay, so we've got TVS saying it's different, context matters, you ignored us, and the Patent Office saying same problem, obvious adaptation, just workshop tinkering.
A clear conflict.
So with these strong arguments on both sides, what did the High Court finally decide? Did TVS get the patent? Did the Patent Office win?
Well, interestingly, neither fully. The High Court actually set aside the Patent Office's rejection order from January 18th, 2021.
Set it aside. So TVS won the appeal.
They won the appeal in the sense that the rejection was overturned, but, and this is crucial, the court remanded the matter for reconsideration.
Remanded. So send it back to the Patent Office.
Exactly. Sent it back for another look.
So no final decision on whether the invention itself gets the patent or not.
Precisely. The court was very clear on this. They explicitly stated, and I'm quoting loosely here, that no opinion has been expressed on the merits of the patent application itself.
So the win for TVS was procedural, not substantive.
You've got it. The decision was all about flaws in how the Patent Office made its decision, not about whether the device itself is actually patentable in the end.
That's a really important distinction. So what were the flaws? Why did the High Court say the Patent Office got it wrong the first time?
There were a few key reasons. First, the court directly addressed the workshop improvement argument.
The idea that adapting it from a car to a bike was obvious.
Yes. The court basically said, hold on. Resolving a problem in one type of motor vehicle cannot be equated with resolving the same problem in a different type of motor vehicle without proper justification.
So you can't just assume it's obvious to jump from pedals to handlebars.
Not without explaining how it's obvious. The Patent Office hadn't provided sufficient reasoning to bridge that gap between the four-wheeler prior art and the two three-wheeler invention.
Okay, so lack of justification on the obviousness leap. What else?
Second, the court found the controller's order just lacked enough reasoning overall. It called it a conclusory finding rather than a speaking order.
Speaking order, meaning an order that explains itself.
Exactly. A decision that clearly lays out the reasons for the conclusion. The original order just stated the components were already present in the prior art.
Without explaining how someone would combine them.
Precisely. It didn't explain how a person skilled in the art would be motivated to combine elements from D1, D2, and D3 to arrive at TVS's specific handlebar setup, and why that would be considered obvious.
Got it. So, poor reasoning. Failure to justify the obviousness claim. Was there a third point?
Yes, and this one's quite significant legally. The controller completely failed to consider economic significance as an alternative way to prove inventive step.
How does that work?
Under Section 2(1) of India's Patents Act, an invention involves an inventive step if it has a technical advance compared to existing knowledge or has economic significance, making it non-obvious to a skilled person.
So it doesn't have to be a massive technical leap. It could be inventive if it provides significant economic value.
Potentially, yes. The law provides that alternative path, and the High Court pointed out that the controller hadn't considered this economic significance angle at all. It was just overlooked.
Wow. So the Patent Office failed to properly justify obviousness across vehicle types, failed to provide detailed reasoning, and failed to consider a whole prong of the inventive step definition.
That's the essence of the High Court's critique of the process.
So it really wasn't about whether TVS's device is inventive, but whether the Patent Office did its job properly in figuring that out.
Exactly. The focus was entirely on the quality and completeness of the Patent Office's examination and decision-making.
Okay, so it's going back. What instructions did the High Court give for this reconsideration?
They were quite specific. First, it has to be done by a different officer.
To avoid bias from the first decision?
Presumably. To ensure a fresh look without any prejudgment. Second, TVS must be given a reasonable opportunity, basically, another chance to argue their case.
Fair enough.
And third, the final decision must be a speaking order. It needs to have clear, detailed reasons explaining the outcome. And this all has to happen within 3 months.
3 months. Okay, so relatively quick turnaround expected.
Yes. The court and a timeline on it.
Now, this deep dive isn't just about this one specific case, is it? It's about the bigger picture. What's the precedential value here? What should people take away from this judgment?
That's right. The real significance isn't about the specific accelerator device. It's about the standards the High Court is setting for the Patent Office.
Raising the bar for how they examine patents.
Absolutely. It sets a clear precedent that future rejection orders, especially those based on obviousness or lack of inventive step, need to have really robust, transparent reasoning.
No more just saying it's obvious.
Pretty much. Examiners need to explain how they reached that conclusion, show their work, connect the dots between the prior art and the invention.
And what about the prior art point, the vehicle types?
That's another key takeaway. The judgment emphasizes the importance of context when applying prior art. You can't just say, a problem was solved over here in cars, so solving it on bikes is obvious, without carefully analyzing the differences and justifying why the adaptation isn't inventive.
So the workshop improvement argument needs solid backing, not just assertion.
Exactly. Examiners have to justify why something is just a simple adaptation versus a genuine inventive step in a different context.
And the third point, economic significance.
That reinforces that examiners must consider all the statutory criteria. Inventive step isn't only about technical advance. They also have to assess, if argued, whether there's economic significance under Section 2(1). Ignoring that path was a critical procedural error here.
So this sounds like a really important decision for ensuring a more rigorous and fair patent examination process in India.
I think it is. It's pushing for greater accountability and transparency from the Patent Office.
So what's the single most important takeaway you want our listener to remember from all this?
I'd say it's the court's strong insistence on detailed, reasoned decision-making and comprehensive analysis by the Patent Office, especially when evaluating inventive step and applying prior art. It's a call for administrative bodies everywhere, really, to provide transparent, justified decisions that properly engage with the details of an invention.
Fascinating stuff. A real look under the hood, so to speak, of the patent system. We've seen how a detail like the type of vehicle can become central to a legal argument, and how crucial that idea of a speaking order, clear, explained reasoning is for fairness and transparency.
Absolutely. Process matters.
So for you listening, maybe think about this. How could this push for more detailed reasoning affect innovation down the line? Will it make inventors file stronger applications, or maybe just create more work for examiners?
And what about the economic significance idea? How much economic impact does an improvement need to have before it crosses the line from obvious to inventive, especially if the technical change seems small?
Good questions. It really highlights that tricky line between improvement and true invention.
It does. This case is a reminder that the line is often blurry and debated, and the process for drawing that line needs to be rock solid, reasoned, and transparent.
Well, thank you for joining us on this deep dive. We hope this exploration gave you some new insights, maybe sparked some curiosity about the systems that govern innovation.
Always a pleasure.
Until next time, keep learning, keep questioning, and keep exploring.